court today is Derrick Martin King versus Ohio Department of Jobs and Family Services. Each side will have 15 minutes to present its argument. The appellant may reserve up to 5 minutes for rebuttal. Mr. King, if you decide you want to reserve time when you take the podium, you let me know how much, and I will do my best to keep you apprised at the time. The arguments are being visually and audibly recorded to be posted online. Please keep your voice up and remain behind the podium. We've read your briefs and we are ready to begin.
Good morning, Your Honors. I would like to reserve at this time 4 minutes for rebuttal, please.
All right.
Thank you. Your Honors, this is the second time that the issues that are surrounding this case have been before this court. A declaratory judgment action was initiated in August 2017, in which the while this judicial review proceeding was presiding. And in that case, this court remanded that case back to the trial court, and where that trial, right now is stayed pending the resolution of this appeal. Okay, there are 5 issues that are the basis of this appeal. A trial court which lacked jurisdiction to enter judgment due to a case that was pending before the Supreme Court of Ohio at the time that the judgment was entered. The unconstitutionality of statutes and court rules for violation of rights of access to courts under the First Amendment. The trial court's reliance on an outdated and inapplicable case to affirm the decision of a state agency. The unconstitutionality of the Ohio General Assembly legislation due to the violation of the rights of the safety under the Ohio Constitution. And the unconstitutionality of an Ohio General Assembly legislation due to the denial of due process of law and equal protection of their right. This oral argument today will focus on one thing, the Daltrey v. Wallace decision, and the reasons why that case is inapplicable and outdated. The trial court cited Daltrey in finding that there is no constitutional right to quote-unquote welfare benefits. However, that trial court did not analyze the law in reaching this erroneous decision. For example, in the case of LT versus New Jersey Department of Human Services, the New Jersey Supreme Court held that a regulation terminating temporary rental assistance benefits after 1 year for recipients who were complying with their obligations under the regulatory program at that time, conflicted with the purpose of general assistance to provide temporary shelter to those in need. And the court said, you have to continue the program. On a more controversial issue, the New Jersey Supreme Court held in Right to Choose versus Byrne that a woman's right to choose to protect her health by terminating pregnancy outweighed the state's asserted interest in protecting potential life at the expense of women's health, and thus the statute restricting Medicaid benefits for abortions necessary to save the life of the mother violated the New Jersey Constitution.
Mr. King, I have a question for you.
You may.
It seems like what you're really asking us to do is basically to do the job of the legislature and tell the legislature you're wrong, you shouldn't have cut these benefits. And I'm not sure the court can do that.
The court has the perfect opportunity to do so when the legislature has screwed up and violated the Constitution. Okay. The issues of general assistance benefits for rental assistance and the right to obtain an abortion at public expense are very much more controversial than disability financial assistance benefits. In 1941, FDR voiced that the United States commitment towards promoting the safeguard and safeguarding basic human rights in his favor, in his famous For Freedom speech before Congress. The third freedom was freedom from want. During his presidency, Roosevelt commented on the duties of Americans to provide for everyone's need. Quote, I see 1/3 of the nation ill-housed, ill-clad, ill-nourished. The test of our progress is not whether or not we want to add to the abundance of what those who have much. It is whether we provide enough for those who want it. As stated in pages 21 through 23 of my merit brief, each of the cited state constitutional provisions support the overruling of doctrine. In addition, Ohio's constitutional right of safety is consistent with prior versions of the Ohio Constitution. For example, the Ohio Constitution of 1802 made explicit that even a pauper's children could attend the public schools. And that's the Ohio Constitution of 1802, Article 8, Sections 15 and 25. In addition, the state amended its constitution in 1990 to authorize the legislature to provide subsidized housing for low-income individuals. Ohio Constitutional Article 8, Section 16, which says to enhance the availability of adequate housing in this state and to improve economic and general well-being to the people of this state. It is determined to be in the public interest that and a proper public purpose for the state to provide housing. I have provided this court with 2 cases from the New Jersey Supreme Court, as well as 6 law reviews, well written by legal scholars in support of the argument that Daughtry must be overturned. This court must analyze all the various state constitutional provisions and cited law reviews. Once the court conducts this review, it will find that Daughtry is outdated and therefore not applicable to the issues contained in it. In conclusion, I will quote legal scholar Dan Braveman, who stated, quote, a state's traditions can also serve as a basis for independent interpretation of constitutional provision. Because a state constitution represents the most basic values, an interpretation of that document must properly rely on the traditions that shape these values. These state traditions may differ from the factual and justified departure from the federal constitutional standard in this regard. Justice Judith Kay of the New York Court of Appeals quite accurately observed, when the state's history indicates some vessel of concern, clearly there might be as well be different result from an analogical constitutional federal precedent. And with that, I'm going to reserve the balance of my time.
You can reserve up to 5 minutes. You want your full 5 minutes?
Yes. Thank you.
Whenever you're ready.
Good morning, Teresa Dirasammer on behalf of the Ohio Department of Job and Family Services. May it please the court. This court should affirm the decision of the lower court, which in turn affirmed an administrative appeal decision issued by ODJFS terminating the disability financial assistance benefits of Mr. King due to elimination of the DFA program. Mr. King has not challenged any of the factual findings of the administrative appeal decision. His sole argument is that that decision is not in accordance with law because he alleges the repeal of the DFA program is facially unconstitutional. Mr. King has focused today on the lower court's reference to the Daughtry decision out of the 2nd District. The lower court did not err in finding that case applicable to the circumstances of this case, and in agreeing with the second district that the safety clause of the Ohio Constitution does not obligate the state to provide any type of public assistance or benefits to the state citizens. Daughtry explained that the safety clause means that the state cannot unduly interfere with someone's opportunity to have safety, but it doesn't convey any affirmative obligations. Mr. King has questioned whether or not Daughtry applies because he doesn't view DFA as a welfare benefit, and he has argued that Daughtry's scope is limited simply to welfare benefits. The term welfare benefit doesn't have a statutory definition. It's taken on more of a colloquial meaning simply to refer to public assistance benefits, which would include the DFA program. But the holding of Daughtry, even if this court doesn't find that DFA is a welfare benefit as more narrowly defined, Daughtry would still have application to the DFA program because it is still public assistance being offered to people who are eligible for it, in this case, disabled individuals. The second district's reasoning is that the clause of the Ohio Constitution at issue doesn't just refer to safety. It talks about entitlement to happiness and attainment of property. So the court reasoned that it wouldn't make sense to read that language as requiring the state to provide all of the benefits that are listed in the Constitution. The state can't reasonably be expected to provide someone happiness, provide someone with property, provide someone with safety in the context of a welfare benefit or public assistance benefits. Mr. King's reliance on law review articles and cases that analyze other states' laws have no application here. His argument is solely under a clause of the Ohio Constitution. So the New Jersey cases that analyze New Jersey law have nothing to do with whether the safety clause of the Ohio Constitution requires the state to provide benefits to its citizens. The lower court didn't err in finding Daughtry applicable in this case, and this court should affirm that and affirm their finding that the elimination of the DFA program didn't violate the safety clause of the Ohio Constitution because the state isn't obligated to provide DFA benefits. Mr. King's other arguments, other merits arguments, are that the repeal of the DFA program violates both due process and equal protection. I'd like to briefly touch on those as well. He advances no argument regarding the due process violation. That really wasn't substantively argued to the lower court other than being mentioned in a heading, and even before this court, he recites language from the 14th Amendment, but doesn't ever argue that he didn't get notice and an opportunity to be heard. He doesn't raise a substantive due process challenge. But there is no procedural due process violation when the legislature takes away a benefit program, eliminates a benefits program.
Counsel, can I stop you in regard to that?
Sure.
In your statement of the case, you say that that he had filed a complaint, Mr. King had filed a complaint that is stayed during the pendency of this appeal.
Yes.
And that was attacking the constitutionality.
Yes.
A declaratory judgment?
Yes, declaratory judgment and injunctive relief.
Why can we even talk about constitutional issues in this appeal since it's an administrative appeal?
So the courts have the authority to determine constitutional issues even in administrative appeals, because the standard of review is to determine whether the administrative appeal decision is both supported by reliable, probative, and substantial evidence and in accordance with law. So the constitutional issues fall under the ambit of whether the decision was in accordance with law.
Excuse me, just interrupting, but you can't raise constitutional issues in regard in an administrative appeal. You can't have an administrative agency saying the legislature's actions are unconstitutional.
Yes, but those are two different things. You can raise a constitutional issue with the agency For as-applied constitutional challenges, you're actually required to, but you are correct that the agency can't determine something to be unconstitutional. It's more to preserve that argument for a court, which can then determine whether or not something is unconstitutional. And it's actually appropriate to bring that through an administrative appeal rather than a declaratory judgment action. Courts have held that this issue, specifically in regard to this assistance program, is committed to a special statutory proceeding under Revised Code Section 510135, which culminates in the appeal to Common Pleas Court and then to courts of appeal. So
But then it
courts have,
seems like, I'm sorry for interrupting you, but it seems like then the common police court would be the trial court, not the appellate court, because all these issues would have to be fleshed out in the common police court.
well, I guess they would be the one deciding that specific constitutional issues for the first time, yes.
Okay, that's all I had. I just was looking at it and I just, there was some case law that made look at it a little differently, so that's all. Go ahead.
Even if the court is deciding the constitutionality issue as more of a trial court than an appellate court, it is still appropriate to limit its review to the record that was certified to it by the agency. One of the procedural arguments, I'll say, that Mr. King makes is that it was, the lower court erred in denying his motion to supplement the record and for production of a transcript. But his underlying argument is a facial constitutional challenge, and courts have held that extrinsic evidence is not necessary for a court to determine whether something is facially unconstitutional. They're simply reviewing the language of the statute, portion of the budget bill in this case. So even though the lower court was deciding the issue for the first time, it was still appropriate for it to confine its review to the record that was certified to it by the agency. Then finally, I'll come back to due process briefly, just to say that the Supreme Court has held that a welfare recipient isn't deprived of due process when a legislature adjusts benefit levels. The legislature has the plenary authority to do so, and it's found that the legislative process itself provides all the process that one is due under the Constitution. His last argument is under equal protection, which first requires a determination as to whether any classifications have been created that treat similarly situated people differently, and then move the analysis on from there. Mr. King's argument is that the way the budget bill phases out the DFA program is an unlawful creation of classifications. So there's two responses I have to that. First is that even if it was, any classification didn't treat similarly situated people differently, it treats differently situated people differently. And then second, even if it was a creation of classifications, it still was rationally related to the legitimate government purpose of phasing out the DFA program. The differentiation that the repeal of the program makes is based on one's status as an applicant for federal disability benefits. DFA is basically a filler program meant to tide someone over while their application for federal disability benefits are pending. And then once that determination is made, one no longer receives DFA, either because they're receiving supplemental security income or they've been determined not disabled, and then they're not eligible for DFA either. So it phases out the budget bill based on one's status as an applicant for the federal benefits, whether they've already received a denial, whether they have an appeal pending. It's purely timing based. It's not based on one's disability status. Everyone in the program should be disabled to qualify for it. So even if disability is viewed as a semi-suspect or a suspect class, it's not based on disability status. And the people that fall under each of the categories aren't really similarly situated to each other because they're in different phases of the application process for federal benefits. So our position is that the phasing out of the DFA program doesn't create any classifications to begin with, and even if it did, they're certainly rationally related to the legitimate purpose of phasing out that DFA program. Again, here, Mr. King argues that strict scrutiny should apply based on a decision out of New York and dicta from that decision in a court that was analyzing New York law and whether disabled individuals might be semi-suspect class under New York law. That doesn't have any application here, and regardless, like I said, the elimination of the DFA program doesn't draw any distinctions based on disability anyway. So it doesn't matter whether or not it's a semi-suspect class. That's not one of the criteria used in the elimination of the DFA program. If there are no further questions, I ask that you affirm. Thank you.
Mr. King? You'll have your full 5 minutes.
Yeah, okay, thank you. And I'm going to address something that Justice Carr stated in regards to the administrative appeal versus the declaratory judgment action. It should be noted that the declaratory judgment action was filed in that trial court prior to the administrative appeal. So I agree, this case should have been settled with the declaratory judgment. But, that's just the way, they insisted that it go through the administrative appeal. As in regards to, her arguments regarding the DFA program, one thing she misstated, you have to actually have a disability, be found to have a disability in order to receive DFA benefits. And she did not indicate, opposing counsel did not indicate that to you, but that is a requirement, and I was found to have be suffering from a disability and, entitled to benefits. Now, in regards to using various other laws from other jurisdictions, when the courts have not determined one way or another in this state, then you turn to any legal rulings from other jurisdictions as well as law reviews, etc. And even if you have a case which is still not inapplicable, because when Daltrey was contesting the general assistance program in its prior version, which that's a whole lot different than what the DFA program is. There's various different requirements, so that's another reason why Daltrey is not applicable. And if there are no further questions,
Thank you, sir.
thank you.
All right, thank you both for your presentations. We will take the matter under advisement, issue a written decision, which will be mailed to both sides, as well as posted on their website and on the